Good evening, ladies and gentlemen, dear President, Provost, distinguished guests, colleagues and friends. Welcome to the annual lecture of the UCL Institute of Human Rights. My name is Veronika Fikfak, and I'm a professor of human rights and international law and one of the directors of the Institute. As many of you know, UCL Institute of Human Rights is a multidisciplinary center promoting research, teaching, and public engagement in human rights. The Institute is run jointly by the School of Public Policy and the Law Department, and today we gather to discuss the role of the European Court in protecting the rule of law across Europe. The last decade has been tumultuous for Europe. We have observed a weakening and in certain places even the erosion of the rule of law. This has most clearly been the case in Hungary and Poland, where extensive judicial reforms were introduced aimed at exerting the executive's influence over judicial appointments. In Russia, politicians like Alexei Navalny were persecuted, silenced, poisoned, and imprisoned. And in the UK, we have spent 10 years debating a withdrawal from the European Convention on Human Rights and the repeal of the Human Rights Act. More widely, governments around Europe have started to question their adherence to the Convention system, and many have refused to comply with judgments of its court. These actions can be harmful to the rule of law and the state of democracy in Europe. And the European Court of Human Rights has played a key role in this context and in holding states to account. During all these developments, our keynote speaker was at the heart of this key human rights institution to decide upon legal challenges of governmental misuse of power and to clarify the scope of the rule of law protections that human rights law provides. We are delighted today to welcome at UCL the President of the European Court of Human Rights, Dr. Marko Bošnjak. He has served as judge at the court since 2016. Before his appointment, Dr. Bošnjak was an attorney and an academic in Slovenia. His main areas of research include criminal law, criminal procedure, human rights law, constitutional law, international law, and criminology. As an attorney, he represented clients in several landmark cases, including before the European Court of Human Rights and the General Court of the European Union. As a judge in Strasbourg, he has presided the Grand Chamber and other chambers in a number of landmark judgments. He has also written several separate opinions, including in the Big Brother Watch case versus UK. Now, just a few points in terms of our schedule today. Dr. Bošnjak will speak about 45 minutes, after which our colleagues Colm and Virginia Mantouvalou will comment on the lecture. We'll then open for questions, and at the end, we are delighted to welcome to UCL the President and Provost, Dr. Michael Spence, himself a lawyer, to deliver some final remarks. But now, let's welcome the President of the European Court of Human Rights.
Thank you very much, dear Professor Fikfak, for this very kind introduction, which obliges me a lot. Dear President and Provost, dear professors, dear students, other distinguished persons in this audience, it's my true pleasure to be here with you tonight, and I'm especially thankful to Professor Fikfak for making this bridge between the UCL and the court for the purpose of today's evening. Indeed, this is part of the court should do, and I, as its president, should do. The court, or justice in general, no longer lives in an ivory tower, isolated from the outside world, in the sense that we communicate with our audience only through our judgments and decisions, and say no more. Times have changed. the way authority is perceived has changed. The ways authority is perceived have changed. Therefore, we need to open up and engage and exchange with all the stakeholders of the convention system, which and not just the convention system as such, but the idea, the mission of protection of human rights and fundamental freedoms is a joint venture, and we need to interact with all the stakeholders, in particular with such distinguished and qualified observers as academia. Be it with professors, they are following our case law and all that we do very closely, and it's very important for us how they react to what we do. And secondly, for us, it's very important to engage with the young people who will carry the torch forward, in the sense that, say, in issues relating to climate change, we often speak about intergenerational solidarity, intergenerational bridge, etc., etc. But it's not just about climate change and challenges of this sort. It's about the future of mankind altogether. We have to empower you to carry the torch forward. We'll speak more about this later on. Now, the theme chosen for tonight is the rule of law, which is one of three central elements upon which the Council of Europe is founded, in addition to human rights and fundamental freedoms and democracy. Now, if we look at the courts, when I speak about the court tonight, I generally refer to the European Court of Human Rights. When we look at the court's mission, it appears that the rule of law is the least visible element of these three, in the sense that we obviously adjudicate on issues of human rights. Obviously, we speak about democracy, because when, say, interferences with human rights are at stake, we often see at whether the interference was necessary in a democratic society. So the court needed to expand on the notion of democracy, or what is necessary in a democratic society. Democratic society, in accordance with the court's jurisprudence, is marked by pluralism, tolerance, and broad-mindedness. So the democracy for the court is not just simple majority rule. It's about these fundamental contents of democracy. Now, when it comes to the rule of law, this has been less visible, as I say. However, in the 21st century jurisprudence of the court, this has become increasingly important, and we'll get to that. Now, in order to understand the role of the rule of law in the court's mission a little bit better, I would like to look at its history, not only at the history of the court, but also at the history of the notion of the rule of law. And I will make emphasis, since I'm in London tonight, to make some emphasis on the UK legal tradition for various reasons. Now, a small digression at the very beginning. You all know about rather troubled waters between the UK and the court in recent years. They are a bit calmer now, and my intention is not to address this in particular. Rather, I would like to underline, I would like to stress the role that UK lawyers and statesmen played, first, in the creation of the Council of Europe, and secondly, in the creation of the European Convention on Human Rights, plus the European Court of Human Rights. Already in 1943, Winston Churchill spoke about the need to create a Council of Europe. He named it like this. He reiterated this in his famous landmark Zurich speech in 1946, in the aftermath of the Second World War, and during the Hague Congress, which followed shortly afterwards. He said that Europe needed a charter on human rights, guarded by freedom and sustained by law. So, human rights sustained by law in order to keep peace and well-being in Europe. That's not the idea that came from Brussels. That's not the idea that came from Strasbourg. This is an idea that came from London. Secondly, then when it comes to the creation of the Council of Europe as such, it was created in 1949 by the Treaty of London. It was created in London. But its seat is not in London, it's not in Brussels, it's not in Luxembourg, it's in Strasbourg. Why is it in Strasbourg? Because the then Foreign Secretary of the UK, Ernest Bevin, said that it was necessary symbolically to put the seat in Strasbourg. Again, the Brits put the seat of it in Strasbourg. And then, in its first sitting of the Parliamentary Assembly of the Council of Europe, still in 1949, Winston Churchill was the key speaker, saying that we needed, that the nations of Europe needed to create a court of justice, as he called it at that time, in order so that the nations might be brought to judgment for any misgivings, etc., etc. So, why do we have the court? For various reasons, but the idea was prominently put on the agenda by Winston Churchill. No need to underscore his importance. Now, furthermore, the UK lawyers played crucial role in drafting of the convention in 1950, and the United Kingdom was the first contracting party to ratify the convention in 1951. So you see how central the UK is for the functioning of the convention system. The convention was the first binding international instrument on human rights. It was inspired by the Universal Declaration on Human Rights, which was adopted in 1948, earlier on. It envisaged the possibility to hold states to account before an international tribunal. This was revolutionary in those times, and it's revolutionary still today. And in its preamble, it emphasized the interdependence between human rights and the rule of law. Already in the preamble, you see this. Now, where does this idea of the centrality of this mechanism, which would also contain a court of law, where does this come from? Well, that's very natural to the philosophy of human rights. Human rights are natural inherent rights of every human individual. And then there are two options. They can be protected by the rule of law. The other option existing, the only other option is tyranny, and then in order to protect against the tyranny, human beings have the right to rebellion against tyranny and oppression. So this is the opposition. You either have the rule of law or tyranny and oppression. Tertium non datur, as they say in Latin. There's no third possibility. Now, the idea of the rule of law as such, again, is essentially British. The first person speaking about this, the term is ascribed to Samuel Rutherford, who wrote a book, he was Scottish, wrote a book entitled Lex Rex in 1644. To be honest, I didn't know this, but when preparing for today's speech, I came about this specific fact. And this was revolutionary for those times, because the idea was to put lex, that is the law, before the rex, the king. So the king is subdued to the law, and the law comes first, and not vice versa, rex, lex. It's the king who makes the law, and the law is what the king says. No, it's the other way around. Now, in the 19th century, A.V. Dicey defined the following key elements of the rule of law. First, the government must follow the law it makes. Secondly, no one is exempt from operation of law, which applies equally to each individual. And thirdly, rights emerge from cases decided by courts. So, rights. You can have a very nice declaration of rights, but in the end, to define the exact content of a right in a given situation, it's a court of law in a contestation regarding those rights that says what the right is and what the law is in a given case. So this gives spirit to the idea of any legal instrument, any legal document, to be a living instrument, a doctrine that we otherwise ascribe to the European Convention on Human Rights, but actually it applies to any legal instrument. The elements to it can be found in Magna Carta Libertatum from 1215. You have certain rights that are already there, be subjected to the justice of one's own peers, judged by the law of the land, etc., regarding the arrest. And some people in continental Europe, I remember my professor of legal history back in Slovenia who said, well, the Brits, they take all the credit with Magna Carta Libertatum. That was not so special. Actually, in many corners of Europe, there were instruments whereby the limits of the sovereign power of a king or a ruler were limited in relation to the nobleman by a legal instrument or charter or some document which limited this power, and the nobleman then resorted to this document to invoke it against the king in one situation or the other. But this just shows that we have true commonalities in Europe. Not that someone is wiser than the Brits or that the Brits are wiser than anybody else. There are other British acts which come to mind to everybody, perhaps more than to me, to the Brits here more than to me. But in the end, there is a strong thesis which has strong elements in its favor, namely that the European Convention on Human Rights is actually a vital codification of common law. Now, what is actually the rule of law? How do we define it in the European context? We spoke a little bit how it played out in Britain. How do we conceive it today in Europe? I spoke to the young doctoral students, and I said that perhaps the biggest challenge for judges of the European Court of Human Rights and for its president in particular is to bring together so different views across Europe. We are so different in so many respects, but then so similar in some others. Now, many things that mean something to the Brits or to the Germans in the framework of the concept of Rechtsstaat, or to the French in the context of État de droit or prééminence de droit, they can be construed in a whole new way within the European architecture. Now, where does the European architecture stand on the definition of the rule of law? The Venice Commission in the 21st century already defined the following elements, and the Venice Commission is an organ that was put together by this architecture of the Council of Europe. And the Venice Commission says it's first, the principle of legality, legal certainty, prevention of abuse or misuse of powers. We will not get right now into the distinction between the two. Then fourth, the equality before law, and finally, the access to justice. Now, where does the European Court of Human Rights stand on this? Now, you can look at our judgments in vain to find a very clear definition of the rule of law as such, which is not surprising. We are deciding on specific cases. And here, again, we are similar to the common law tradition. The law arises from adjudication of cases, from adjudication of disputes between individuals or individuals and the state. Differently from, say, the European Union and the Court of Justice of the European Union, where usually they go differently about how the law is made, mostly. Now, what can be still discerned, or how does this work? Still, you can discern certain constitutive elements of the notion of the rule of law. One being access to court. And here we have a UK case, a case against the UK, which guides us into this. The case of Golder versus the UK. It's an ancient one. I was a little baby when the court adjudicated on this. And for those who are perhaps too young to know anything about it, or have not really plunged that much into this case, just a few contours. Mr. Golder, the applicant, he was a convict, serving a prison sentence. He was, he allegedly attacked a guard in prison, and he asserted that this was not true and wanted to bring a claim for defamation in court. And for that, he needed an access to a solicitor who would bring a claim for him, because he couldn't bring it himself. But he was prevented from contacting a solicitor for this purpose. And if you look at the European Convention on Human Rights, it never says very clearly that in a civil case of defamation, you can contact a solicitor for this purpose. It never says you have an access to court as such in any given situation. Just when the case is in a court, then certain guarantees of Article 6 apply. But the court says, well, in order for the Article 6 guarantees on fair trial to apply, you first have to get to the court. The access to justice is the first step. So it ruled in favor of Mr. Golder. Second element, the element of legality. Now, what is now legality? It can be conceived in a very formal way. You have to have some legal basis for what you do. So the government or any formal state institution needs to play by the rules adopted. It adopted. But it's not enough. It's not enough because those can be any rules in the end that could in the end lead to tyranny. Our court, the European Court of Human Rights, explained more in detail what the legality entails. In addition to existence of some legal basis, that legal basis needs to be accessible. An individual concerned by the norm needs to have access to this legal basis in order to understand what applies. Then, in connection to this, that legal basis needs to be foreseeable. The individual needs to understand what that rule empowers the state to do in a given situation, or empowers him or her to do what is prohibited and what is not. Perhaps not everybody is a legal expert, but as we say in Strasbourg, if you don't understand it yourself, the norm should be such that with the help of a legal expert, of someone who is knowledgeable in law, you understand what is prohibited and what is not, either for you or for the state when it interferes with your rights and freedoms. And finally, it needs to protect an individual against arbitrariness, against tyranny that we discussed earlier. And here, may I make a link to the democratic society. One of the other, I said there are three elements crucial for the architecture of the Council of Europe, apart from the rule of law, human rights, and democracy. And in cases relating to secret surveillance, which is the most sensitive element of how state power can interfere with the individual, precisely because it allows for surveillance and because this surveillance is secret, the court made a link with the democratic society. So when you see the court adjudicating the cases on secret surveillance, like very prominently, Professor Fikfak mentioned my concurring opinion. I thought that the court did not go far enough in protecting individuals in the Big Brother watch and others against the UK, the court nevertheless made a link between protection against arbitrariness and the democratic society. So protecting against arbitrariness in a democratic society which guarantees, again, tolerance, pluralism, broad-mindedness. No big brother as such which tries to really make us uniform and succumb us to the state power. That's very, very important. The one does not go without the other. We have ample case law regarding this, and most recently, last year, in a Polish case, Pietrzak and Bichawska-Siniarska versus other, we reiterated how crucial this is for the rule of law. And finally, another element, protection against abuse. Now, one would say, well, dear President of the European Court of Human Rights, you already covered this when you spoke about protection against arbitrariness. No, not really. Abuse goes further than this. And we saw it in the case of Navalny versus Russia. Very clearly, when the court, for the first time, very clearly adjudicated on issues of Article 18 of the Convention, and I will explain. I believe that everybody here in this room knows the name of Navalny. And we should mention this name time and again. I remember that the idea of putting him down permanently was to silence his voice and silence his name. And the first reaction of every democratic human being in the world should be, his name should be reiterated, his name should be repeated. So we repeat it in this classroom. It's very important. Now, Mr. Navalny, he had his case before a court. He came himself to Strasbourg in the Grand Chamber. He, next to his representative, he also pleaded it himself. He took the floor himself. He was very strong and very powerful in this. He had several cases bundled together about Article 11 of the Convention. Freedom of manifestation, inter alia, is covered by this article. Mr. Navalny, he was engaged in various manifestations in Russia against the Putin regime, and on each such occasion, he was singled out, he was picked out from those manifestations and sanctioned in one way or the other. Sometimes detained for a few days, sometimes fined, sometimes put in all sorts of proceedings, etc., etc. And he claimed that this went beyond simple violation of Article 11 of the Convention. He said that this was also a violation of Article 18 of the Convention, which prohibits abuse of interferences with the Convention rights for the purposes which are incompatible with the Convention. And the court in the Grand Chamber adjudicated on this and found that this was also a violation of Article 18 of the Convention because the Russian regime used precisely its repressive powers in order to silence him personally when criticizing the regime, when exercising the most fundamental convention freedom under Article 11 of the Convention. Now, let me make one digression before going further in my lecture. Convention is an instrument of like-minded states. That was the idea. This is why it was at the very beginning only signed by 10 states. Those who were like-minded and shared the values. The idea was that there would exist an ever-growing level of protection of human rights, democracy, and the rule of law in Europe. So we are moving in the right, better direction all the time. Then, the number of member states, of seemingly like-minded states, increased especially in the golden 90s, as we call them, there was an optimism across Europe. Yes, finally, Europe is coming together, and is coming together around those fundamental values. And when I see young faces here, I was in your shoes at that time. And why I'm saying this, we thought everything was possible. Professor Fikfak and I, we come from Slovenia, which in early 1990s became an independent country, but not just that. It also turned from the socialist system to a system ruled by law, democracy, and human rights. And we thought everything would be going for the better all the time. We were full of optimism. Everything was possible. Now, I hear from young people of your age very often, well, everything is going down. We are worried about climate change. We are worried about war going on the European continent. We are seeing so many negative signs all around the world. This is all going down. The future is in your hands. Take it, seize it. Carry the torch further. Don't believe that everything, les jeux sont faits, as the French say, that everything is settled and done. No, everything is open. Go for it. Now, after this part of digression, it is true, however, that opposite tendencies quickly start to show in Europe in the 21st century. These negative tendencies culminated in the Russian invasion too, I will rather say it like this, Russian invasion in Ukraine on the 24th of February 2022. We gathered in deliberations in a Grand Chamber case, we, the judges of the court, and it had nothing to do with Russia, the case, but the atmosphere was so grim. We knew that certain period of the conventional system ended that morning. Now, that was a culmination. In parallel to that, we have seen, and we continue to see, the rise in populist movements and finally governments, because they win elections here and there, which are questioning the fundamental elements of the conventional system. They are furthermore asserting their direct legitimacy, saying, we are democratically elected. You, the judges, are not. You, the judges in Strasbourg, come on, where's your legitimacy? And they take issue with their domestic judiciary too. They say, well, you, the judges, domestically, don't have this legitimacy. We will start judicial reforms of various sorts, which very often strike at the heart of the idea of the shared responsibility. Because when we speak about the convention system, we all quickly think about the European Court of Human Rights. And that's all nice and fine, and the court is important. But we only come at the very end. It's a system of the shared responsibility. It's first and foremost the domestic judges and the domestic actors who need to make sure that the human rights and fundamental freedoms are protected by the convention, are indeed protected domestically. I very often say, and my colleagues very often say, it's not my invention at all, we say that, a judge at the circuit court somewhere in the UK, or a judge at the first instance court in Ljubljana, Slovenia, or somewhere else in Greece, for example, or in Ireland, is actually the first instance Strasbourg judge. So the judicial reforms domestically strike at the heart of the conventional system. And they do it in various ways, either by appointing those in the conformity with the wishes of the government to the judicial post, or by striking at the security of tenure of those judges who have been appointed previously, by dismissing them, by otherwise sanctioning them, by moving them to another court, etc., etc. And if we look at the first set of steps taken regarding appointments, here, luckily, and we did not know what storm was actually coming, but we picked a right case to adjudicate. We picked a case from Iceland, Astradsson versus Iceland, regarding the judicial appointments. The case was about an infraction, a road traffic infraction in Iceland. They punished this very severely. The gentleman was severely sanctioned, the applicant was severely sanctioned in the court of first instance, turned to the court of second instance, the newly formed court of appeal in Iceland, and his case there was heard by someone who, in his view, was appointed in a way which was incompatible with the convention principles. And he said, this way of appointment was so politically and otherwise tainted that it did not comply with the requirement of a tribunal established by law, which is one of the convention requirements. And the court said, yes, it's true. The process in your case, in Iceland, was so tainted that this is incompatible, hence violation of Article 6 of the Convention. Luckily, the case came from Iceland and not from Poland or Hungary or some other country, so that later on, when we applied the logic to Poland, to Hungary, to some other countries, they couldn't say, well, you are picking at us, you have double standards, you never say anything alike regarding Western democracies, well-established democracies, you're just picking on us. And we reiterated this logic in a number Polish independence of judiciary cases where, say, cases of an individual were adjudicated by judges appointed in various proceedings which did not comply with the convention principles. When it comes to the security of tenure, here the first prominent case was Baka versus Hungary, which is also cited or referred to in the flyer advertising my today's lecture. Mr. Baka, he was president of the Hungarian Supreme Court, severely criticizing the envisaged judicial reform in Hungary, where they wanted to transform their Supreme Court in another apex court called Curia, which would not be just the change of label, but would also entail that the then president, namely Mr. Baka, would no longer be the president, but another new president of that new Supreme Court would need to be appointed. And he turned to Strasbourg, to our court, and we said, yes, this was violation, because this was only a pretext to silence Mr. Baka. So either you comply with us and our wishes, and you remain president of the newly created, of newly transformed Supreme Court, or you criticize us and you will no longer be president. Now, the logic from that judgment was upgraded in various ways in a number of Polish cases, Grzęda, Juszczyszyn, Tuleja, Żurek, all judges in Poland who criticized the Polish judicial reform and were sanctioned or otherwise negatively impacted because they criticized the government's intentions and fought for the rule of law and applied our jurisprudence, the jurisprudence of the European Court of Human Rights, or applied the jurisprudence of the Luxembourg Court, of the Court of Justice of the European Union, directly in their jurisprudence. But because the government was unhappy with our jurisprudence or the Luxembourg jurisprudence, they said, you'll be sanctioned. Now, number of judges in Poland, they ran for help to Strasbourg and requested that we issue Rule 39 measures, interim measures. These are special measures that our court can exceptionally grant in order to prevent occurrence of serious harm. We issued such Rule 39 measure in the so-called Rwanda flights. So this is something well known in this country. And it was respected by the then government when we issued it, but also the Polish government respected the Rule 39 measures that we, the then Polish government, respected the Rule 39 measures that we issued in order to protect the judges of the Polish courts against repression for them speaking loudly in favor of the rule of law. Our jurisprudence culminated in the case of Wałęsa versus Poland. Again, Mr. Wałęsa is well known to those with some gray hair in this room, but not necessarily to younger generation. He was an opponent in early 1980s, leading the movement Solidarność against the Polish communist system, was sanctioned then, was later Polish president of the Republic in democratic times, received the Nobel Peace Prize already in the communist times. But then there was a clash between him and the populist Polish government. A protagonist, a proxy of that government, accused him of being actually a spy in the former communist system. He started defamation action against that gentleman, won the action. But then, after some 10 years, I think, the Polish populist government put in place a special legal remedy which would be heard before a special chamber which they designed and they packed with their people, which would then overturn that judgment. And it did overturn the judgment of Mr. Wałęsa. And Wałęsa, he said, well, this was not in accordance with the law, not in accordance with the legal certainty. I wanted to rely on that judgment in defamation proceedings. And secondly, I was judged, my case was ruled upon by people who really were appointed against all fundamental safeguards of the rule of law. We ruled in favor of Mr. Wałęsa. It was a historical moment. We felt it in the room when we deliberated on the Wałęsa case. And luckily, the new Polish government, and here I come to the fact that if things go down for some time, they can go up again. The new Polish government sent a letter and said, we will not challenge the Wałęsa case in the Grand Chamber, which in principle they could try to do. We said, we will not do this. Rather, we will implement all your judgments and decisions regarding independence of judiciary cases and the rule of law. So the wheel of history can turn again to the positive side. Just be persistent and fight. Now regarding challenges ahead, and I'm looking at, I still have some 10 minutes plus, some 10 minutes, will not surpass it because it has to be dialogue. I said we need to exchange. It should not be a monologue. Regarding the challenges ahead, I said we are celebrating this year the 75th anniversary of the convention. We have quite a mature case law. We have quite efficient case processing mechanisms. We are not champions of that at all. And we have certain institutional weight. We tend to be respected in Europe and around the world. For example, our climate change ruling in Verein Klimaseniorin in Schweiz versus Switzerland was a source of inspiration for the South Korean Constitutional Court when they ruled in the same way in late August last year. So we have some global outreach. And I received letters from the President of the Supreme Court of Canada and Mexico recently, in the recent weeks, wanting to join our Superior Courts network because they, as observer courts, because they want to learn from us. And we want to learn from them too, for example. Now, there are certain future challenges. Of course, some are continuous. They are continuing from the existing ones or developing further. There are new ones. We're always unpredictable. We couldn't have predicted COVID at that time and needed to adapt. And we cannot predict what is coming just around the corner. There will be new challenges, unpredictable ones. And there are some, and some are obviously present and on the horizon. One is, of course, climate change. I refer to the judgment in the case of Verein Klimaseniorin in Schweiz versus Switzerland, which is a ruling that some of you, or many of you, surely know. It was criticized because we find for the applicants in that case, or for the applicant association at least in that case, and found violations of Article 6.1 and Article 8 of the Convention. We were accused of straying into the realm of environmental policy, which is actually in the domain of the legislative and administrative branches of government, or that we purely played politics, some said. I disagree. What we said in that judgment should be no surprise. We said that climate change exists, so no climate change denying. It's anthropogenic. Human beings cause it. Thirdly, the connected phenomena that stem out of climate change and the risks, they affect enjoyment of human rights, most prominently rights under Article 8 of the Convention. This inevitably triggers positive obligations of states. We just need to define them very clearly. But this is nothing new. If something affects human rights, states must act upon it. That's as simple as that. And once we define those positive obligations under the Convention, states can be held to account whether they meet them or not. So this is not really something novel or unexpected. Now, it's true that there are difficult issues, and we had to tackle them, say victim status, definition of those positive obligations, how to monitor this, etc., etc. This is not easy at all, and we can discuss this further, but here we are. Then, and the second thing I want to briefly mention, it's mentioned more in detail in my paper, and it can be made accessible by your university. If it has not yet been made available to everybody, it can, I give my permission to do so. It's new technologies. First, in connection to the need of democratic societies and processes to have reliable information upon which they can build. We live in times, first, of fake news, which remain unchecked very often, and which make their way massively, especially to young people, to people who will decide our future in the end, through social media and the like. And here I would like to make reference, and we can discuss this further if we have time, the case of Sanchez versus France. Then, the exponent of all this is artificial intelligence. We have no direct cases on artificial intelligence yet at the court. The closest one that gets to the phenomenon of artificial intelligence is Glukin versus Russia. The applicant performed this, or how would you call it in English, a solo manifestation in the Moscow subway and left. He was then tracked down with the use of surveillance cameras, face recognition, vehicled by the artificial intelligence. And he was then apprehended, sanctioned, and whatnot. It's no fun now in Russia regarding this, I assure you. And the court found violation of several convention rights because it simply was not foreseeable that he would be monitored in this way, tracked down in this way, and sanctioned in this way. One of the elements. And this connects very clearly to the issue of rule of law that I was speaking earlier, especially in the context of surveillance. Now, though we don't have direct cases of artificial intelligence really yet, we are looking closely at the phenomenon. We organized this year's judicial seminar, which is the main judicial seminar held at the court last Friday, precisely on the artificial intelligence, because we wish to understand the nature and, of the phenomenon, its risks and potentials, especially when it comes to the use of data, the unforeseeability of what are the elements or data on which the algorithms are trained. Then we have the idea, there are ideas of AI taking decisions, and they are described in detail in my paper. Here, the question is, on what basis are those decisions taken? How are the individuals involved protected against arbitrariness? Again, the rule of law phenomenon. How can we protect individuals against discrimination in that? They are perhaps targeted because of their race, gender, social background, migration, etc. The issue of equality, again, the rule of law. And finally, the access to court. If it's the artificial intelligence deciding how does this rhyme with the idea of access to court, which was adjudicated way back then in the case of Golder versus the UK? I'm not saying that there is no room for the use of artificial intelligence, but we have to be vigilant about these fundamental rule of law principles if we consider applying artificial intelligence in one way or the other. Now, I said, we would dialogue here. We would exchange here. This is why I will stop. I can't wait to hear from the two professors reacting to my speech, and then, of course, to hear what your queries and thoughts on the topic of today are. Please. Thank you.
Very much. Thank you very much for the talk. And I hand over to Virginia, who's a professor of labor law and human rights, to give her comments.
Thanks very much, Veronika. President Bošnjak, thank you very much for your very powerful lecture that examined the foundations of the European Convention on Human Rights and its importance for the rule of law in Europe. You reminded us of the role of the UK in the creation of the European Convention on Human Rights, which is sometimes nowadays forgotten and not accidentally, and it was really important to do that. Thank you also for highlighting the value of access to justice and the independence of the judiciary for a democracy that protects the rule of law. The case law of the European Court of Human Rights that you summarized was fascinating, and it's clear that these rulings, particularly the Polish rulings, are very, very important in recent years. Unfortunately, I don't have anything to disagree with you about. I thought your lecture was excellent. And I normally like disagreeing. In the final part, you referred to recent challenges, including the environment and technology, and explained that the court has already taken important decisions in this area, both in relation to the environment that we have discussed, under the auspices of the Human Rights Institute, and in relation to technology and artificial intelligence, these new challenges. These are very positive and welcome rulings in my view, in my view indeed. I want to mention a few different topics, a few other new challenges that the Strasbourg Court has a central role to play, and a duty. The court has a duty to provide a voice and access to justice, the possibility for access to justice for individuals and groups who are underrepresented or not represented at all in politics, people who may be trapped in poverty and social exclusion. Some of the most, I think this is one of the most pressing issues in our times in Europe and elsewhere. I have in mind the example of people who migrate either as asylum seekers, refugees, or economic migrants. Some of these economic migrants are employed across the Council of Europe in some of the most challenging work sectors where we're in desperate need for workers, such as agriculture, care work, and domestic work. The court has, over the years, particularly the last few decades, has taken important decisions protecting their rights of migrant workers, asylum seekers, refugees, and other migrants, and I hope that it will continue to do so. Very sadly, as you know, there is widespread rhetoric, both in the UK and elsewhere in Europe and further afield in recent years, that dehumanizes migrants. Rhetoric and policies that a few years ago would have shocked us here, all of us, or most of us, not here in this room, obviously, but also elsewhere, they are becoming increasingly normalized. The same can be said about rhetoric involving people who live in poverty and exclusion. I have in mind welfare claimants that you mentioned in your talk, and prisoners. The increasing dehumanization of these groups is striking, and I hope that the court will continue to protect their rights against this. We appreciate that there are challenging times ahead and a difficult balance for this court for this court to address. There is sometimes a hostile political environment against the court's rulings. the possibility of populism that we witness in the UK, in Europe and elsewhere, misrepresentation of the court's decisions, and a possible broader backlash that we witness across Europe and elsewhere, and in the UK, of course. All these factors are important for the court to keep in mind, and I'm sure that they influence your work every day, the work of the judges of the court. But you should know that those of us who are committed to human rights and justice, and it is not just us here at UCL, we always await your judgments eagerly on all these issues. We know that these rulings cannot address all injustices that you described, all the challenges to democracy, the challenges to climate, the challenges to, from technology, issues of migrant workers, and all this. We know that these all cannot be addressed through the court's rulings. However, the convention is as important today as it was when it was first enacted. My co-director of the Human Rights Institute, Professor George Letzes, who is here tonight, has written in his influential monograph about the value of the idea of the living instrument, the European Convention on Human Rights, as a living instrument, and the fact that the convention has to be interpreted, should always be interpreted according to present-day conditions. This is essential to values of equality and dignity that underpin the convention and gives the court important tools to address all these contemporary challenges. As academics, of course, we always, and we will continue, as you know, and we were discussing earlier, we will always scrutinize your decisions very closely to make sure that the court is always true to these values, interprets the convention in a way that is true to these values. It's important to highlight that our analysis will always be grounded, our analysis as academics and as individuals committed to human rights and justice and the rule of law, our analysis will always be grounded on our endorsement of these ideas, the importance of individual justice, but always a belief, in my view, that the court's rulings can at times set in motion political debates, democratic debates, and political processes that can lead not just to individual justice, but also to broader structural reform in line with human rights values and the rule of law. Thank you.
Thank you very much. And I turn to Colm, who's a professor of constitutional law and human rights.
Great. Thank you, Veronika. First of all, I'd like to join Virginia in thanking Justice President, I should say, Bošnjak, for giving a wonderful lecture and for coming here and engaging with us. Every judge I've ever met always has interesting things to say about academic reactions to their judgments, because they work incredibly hard to build a judgment and to get consensus in a room and to reflect the arguments that are put in front of them. And then academics like us write very rude things indeed. Well, not always rude, but sometimes very rude things indeed. So it's always wonderful to see judges coming and engaging with us in this way, and this is, I think, important. It's also important, of course, as a global institution for UCL to hear voices leading judicial authority like President Bošnjak to come and talk to us and to sort of give this sort of wider global perspective, because, of course, our debates about things like rule of law and constitutionalism and democracy tend inevitably to be very siloed in our national legal systems. There's always the danger of what the German sociologist Ulrich Beck referred to in the 1990s as the error of methodological nationalism, where you sort of presume that your national frame of reference contains all the information and all the perspectives you need. And it's very important to hear voices that come not alone from outside that perspective, but also which come from regional or international institutions which have an overview of many different systems. And I'll come back to that point at the very end of my short contribution. Rule of law, it's a wonderful idea. Us lawyers get very teary-eyed about it. We sort of fill our students with sort of passionate devotion, and all lawyers running around the world professing great faith and confidence in the idea of rule of law. Of course, famously, as President Bošnjak has said, no one is entirely sure what is meant by this wonderful concept, but we all agree it is a wonderful thing. If we cut through a lot of the discussion and simplify things, we are talking about the idea that power should be channeled through predictable form, that the use of power should be contestable through courts as a mechanism of checking that power has been channeled through appropriate form. And we also have this idea that the use of power shouldn't be completely discretionary, that individuals and groups shouldn't be subject to the uncontrolled, untrammeled power of the state. So that's the basic idea of rule of law. We're now at a particular time in human history where much of the sort of wide social and political consensus that had grown up around the value of the idea of rule of law over the last 30, 40 years in particular is now seriously contested. And it's been contested in different ways, but you see a common theme in a lot of the contestation, which is the idea that it's time to move fast, that it's time to take the leash off state power, to use state power in untrammeled ways, free of sort of checks and balances, that it's time to free up government action. Of course, different political actors have radically different views as to what freeing up government action entails. But you see it in state after state across the liberal democratic world and across the globe more generally. This clamour for power to be unleashed, even if people don't always agree as to who that power should be unleashed against. And you see this across Europe in different ways, and it leads to a sort of impatience with rule of law institutions, attacks on international courts, attacks on regional courts like the European Court of Human Rights, attacks on national courts, because they're seen as part of the system of constraint, of checks and balances, of surveilling compliance with rule of law in important ways to maintaining this balance. And it's a debate that's global. Even now as we speak, to take a non-European example, you're having fascinating rule of law issues emerging in governance in Washington, D.C. I have a friend who is a lawyer in USAID, the US global agency charged with giving aid, who does not know whether his job exists or not at the moment. And this is an institution established by an act of Congress, which may or may not have been abolished over the weekend. This is a rule of law issue. It's unpredictable, uncertain, and potentially the use of discretionary power. So we see this coming up everywhere. So to conclude then, having identified this problem, I want to return as a final statement to the point I made at the very beginning about the value of looking outside of our national silos. The European Court of Human Rights plays an essential role in this regard. It's always played a key role in identifying problems within the tunnel vision of national legal systems. Practices and customs establish law that might seem obvious internally within a country, but actually struggles to survive under scrutiny. Are laws and practices that actually may discriminate against particular groups who don't have the political power to challenge those perspectives. So the Court of Human Rights has always played an invaluable role in challenging that tunnel vision, in encouraging a real focus on human rights values, in looking and learning. And I think President Bošnjak's contribution this evening has been part of that dialogue, and it's part that we as academics within the Faculty of Laws, within our new fabulous Global Centre for Democratic Constitutionalism, within the Human Rights Institute, that we try and drive forward through our academic work. So it's wonderful to be in dialogue with President Bošnjak about this. Thank you.
Should we open up for questions? Oh, sorry, we need microphones. Yeah, right here at the front.
It's coming.
See how close to it. I'm not a professional microphone user. Thank you very much for a wonderful talk, and thank you for the responses. I had just a quick kind of pondering question, because part of your talk was about some of the horizon dangers, such as the technology issue. So I was going to ask about that. In 2022, the English legal system had something like 60,000 outstanding cases that needed to be dealt with and administrated. And an ex-judge, then MP, gave a talk in Harvard where he says the obvious answer to deal with this is AI, right? And the number of, I'm not saying, I won't go into how AI would deal with this, but a number of, the number of papers in journals that are espousing the use of AI, not only for administration purposes, but also in some cases for judicial, judicial assistance, as it were, even the provision of judgment in some cases is exponentially growing at the moment. In my profession, which is philosophy, my discipline I should say, we're now even getting papers that are arguing that journals should be publishing philosophy papers written by AI systems because they might be better than the ones that we're writing. So my question, to come to my question is, what role